So,
okay, let's move into the third question for the evening. And this is from Simple Math in Sumter Township. And Simple Math asks, is a handwritten receipt legally binding on the sale of a house? A friend of mine sold me her house for very little money, and now a year later she wants to take it back. But I have a signed receipt from her and her ex-husband. From Simple Math in Sumter Township.
well, I love the alliteration on that one.
Yes.
What they're alluding to, my clerks who are first and second year law students, even they know the only good receipt for the purchase of a property is going to be a deed.
Right.
Okay, pretty much. I mean, or a land contract, which would be a memorandum of land contract,
Right.
but that's the best receipt is a deed. You should say deed at the top of the receipt, and anything less is not very good. So a deed unto itself, believe it or not, internally, the law looks at a deed as a contract. There's an offer, and there's really not an acceptance, but the delivery of that deed and the acceptance of that deed becomes an offer and acceptance. But the grantor of the deed is showing their intent as to what the contract should be, which is a price of a property, the legal description of the property, okay, and who they're giving the property to. That's the best receipt, number one, but it is a contract unto itself. It shows the grantor's intent. Now, does it show the party's intent? Believe it or not, people can refuse the delivery of a deed. Just because somebody writes a deed, I mean, if I have a terrible piece of property, I want to get rid of it, I don't want to deal with it, I could say, oh, here you go, Blair. And now, you might go, oh my goodness, he just got rid of the worst like Roach Motel and he put in my name. Now I'm in trouble. Well, that doesn't happen because you have to accept the deed. That's the other part of the contract, the acceptance, right?
So I can't just throw a deed at you and run away. It's your problem now.
You throw a deed and run, okay? But people think that, you can do that, right?
Like the keys in Seinfeld, where he just drops the keys at the homeless guy.
Okay, no Seinfeld references. Not everybody gets Seinfeld, and we don't want to waste.
David and I are Seinfeld fans. Seinfeld fans.
But getting back to you, or like your Roach Motel that I'm trying to get rid of, the whole idea about let's pretend for a minute that these people had an agreement, though, where the seller a year ago said, hey, I'm giving you the property. Yes, it's a lower value, but if you do all these repairs, it's your house. I don't want it. Here, I'm putting it in writing. But you can't find the receipt or what have you. Well, that will be very helpful to go to court with. Basically, it's an exception to the deed, and it's called what we call partial performance. It's not what the courts like to see. They'd rather see a deed. Okay. But if somebody like acted in good faith on, let's say, repairing a home or paying taxes, I have a case right now that we're working on right now where we have a family in West Bloomfield that we're told, if you take care of the taxes, if you do this thing and you take care of some water bills, etc., we're going to deed you the home. So this family was so excited, and they did have like some emails back and forth, and they did exactly what they were told to do. And the owners there live in Arizona. They moved out to Arizona. So these people did everything they were supposed to do. Do they have a deed? No, they don't have a deed, but they have a promise for a deed. And according to the promise, they said, we will give you the home. By the way, they weren't giving it for free. We're giving it to you for X amount. If you take care of this. And so what did the people do? They took care of what was requested of them. They agreed by doing the performance. It's called partial performance. So just because you don't always have something in writing, which is a requirement under what we call the Statute of Frauds in Michigan as well. By the way, the Statute of Frauds is one of a very old, I hate to say legislation, it's a legal concept which basically says all real estate transactions that last beyond a year that involve real estate need to be in writing. Why? Because people's memories fade. You're dealing with valuable assets. So this is how we protect people, by making sure they put everything in writing. So what's one of the exceptions to this statute that requires everything be put in writing? Partial performance. showing that you're doing something based on a promise.
Mhm.
Okay. If you're watching this, it's a pain in the ass to do. Go get yourself an attorney before you have to do it, right? Because it's a harder road to toe when you have to go in front of a judge and prove to them all the things that you did to satisfy this unwritten agreement, you know,
Right.
an agreement that wasn't reduced to writing. And I have a lot of those. We have a lot because people are trusting. And it's unfortunate, and they should go to an attorney before, not afterwards.
Mm-hmm.
Oh, we're going down that rabbit hole. Sorry. Okay, so that's pretty much it, you know?
Okay.
What was the question? What was that question?
Is a handwritten receipt legally binding?
Yeah, I know, I'm kidding with you. But yeah, it's unfortunate, but they could enforce that if, you know, if needed be. We'd have to talk to them a little bit further. Okay.
I'd be so interested to see that receipt.